All right, it is April 4, 2025. The stock market is down massively this week. And what we are talking about today is incompetence, not of certain individuals who are attributed to causing this collapse, but of incompetence of counsel, a principle in immigration law that we will discuss. That the one sentence summary in the topic today is: when can incompetence of counsel result at federal court in a decision being set aside?
And the one-line answer is very rarely.
The one-line answer is very rarely. I get the sense that it's being argued more.
Yeah.
I don't know if that's your sense as well. Like, I get inquiries about it more. And why don't
We're joined by Arshdeep, who's been on the show before, and is familiar probably to a lot of you because he has his own social media platforms and is a well-known member of our bar and community. Does a lot of public speaking as well. So welcome back to the show, Arshdeep.
Thank you, Diana. Thank you.
Right. I completely forgot to introduce Arshdeep. Arshdeep was on the show, as you mentioned before, in a very well-received episode about flag polling. And Arshdeep had won a case in which the federal court found that because flag polling is a common process, that it essentially was not misrepresentation to not disclose a denial of entry to the United States during the flag polling process in a subsequent application. A couple weeks after your decision came out, there was another decision, SAMRA, that distinguished it. So it took a little bit of the certainty away, and we're kind of waiting.
They're talking about it.
They're talking about it. In SAMRA, I think the difference, at least that some people are trying to use to distinguish, was that in Arshdeep's case that he won, the person said that he had gone to the US, but he didn't know that the denial of entry was something that needed to be disclosed. Whereas in SAMRA, a person said that they had never been to the United States at all.
So, it actually, as a backdrop for this conversation today, I'm just musing that you posed the question, Steve, about why are we seeing so many incompetence of counsel cases, and I think it's the right question to start this conversation with. To me, there's a couple of reasons for that, but I'd love to get both of your thoughts on this. To me, one of the reasons is because there has been an overall shift in how immigration is running right now. And this is something that I hope he won't mind my saying this, but Robert Blanchet, who's on the Canadian Bar Association executive, said that really the immigration scheme has become a set of rules for how to enforce. It's no longer like who do we want and how do we want to invite people, but rather like how do we prevent immigration? And so as advocates and representatives, it's become extremely challenging navigating the system for people because it's really just you're trying to lead your client through a field full of landmines. And if you happen to land on a landmine, either through negligence or fraud, malintent, whatever the case may be, you may forever eliminate an option that they will not be able to replace. And so things are just much more fraught to begin with. And also things in the immigration field, people are looking at things more from this perspective of like what has gone wrong. So like, not filling in a form properly, not ticking one tick box. Those are the types of things that will prevent immigration. There's no facilitative approach. So there's that. But I think also, to me, what we're seeing with both the immigration department, with the courts even, is that there's a much more punitive kind of perspective taken with respect to the role of counsel. Not just like even with the department in general, like we are not really, and this is again something that I talked about with with Mario Bellissimo, and again, I hope he will forgive me for speaking on his behalf and in his name, that like, are we still being treated as a stakeholder?
When you say we, are you referring to the bar?
Like, are immigration lawyers still being considered as a stakeholder where we have information and we have expertise, and we are like, look, this is not working properly. No, we're going to keep going ahead with these artificial intelligence tools. No, we're not going to show you what those enforcement flags are. It's become so much more adversarial with our relationship with Department of Justice. Anyways, this is a big long rant, but this is kind of, to me, what all of these things have led to, like an increase in this environment where incompetence of counsel has become a whole different line. Sometimes, there's definitely clear-cut cases where somebody just phoned it in or they made mistakes, but it's very easy to do something that will cause very dire results, even where somebody is really killing themselves to do everything possible in order to advocate effectively for their client. So
yeah, I think that's going on. I think it also can just be attributed to the fact that more people are aware that this is an avenue that could be pursued. And as with anything else, as word spreads on social media, this podcast alone is probably going to result in people listening and thinking, oh, I can get my refusal set aside by alleging incompetence of my former counsel or consultant.
yeah,
So I think that it can also, as much as there are those problems with the system, and increasingly fixing problems within the system outside of the federal court is becoming increasingly difficult. So I
for
agree with
sure.
you there. I think it's as much just increased knowledge that this is something that can be done.
Perhaps there's also people who are committing outright fraud, duplicity, taking money to, there is 100% an uptick in that. And, we're seeing cases frequently, people who have even been disciplined but continue to act. And so there's, the fact that there's an increase in fraud is not something I'm trying to debate. I agree. So I think it's not one thing. It's all of these things combined, which is why we're seeing an increase in my view.
You must
I
each have
think-
stories. Sorry, go ahead, Arshdeep.
I'm so sorry. You can go ahead first. Yes.
No, go for it.
Okay. So I think incompetence of counsel is the final stage of the whole problem that we are discussing. It is even important to see how to avoid to be at this stage where you have to think about whether to plead this as a ground of appeal or as a judicial review ground in the court. How can people avoid this kind of situation where they have to think whether to choose this as a ground of appeal or litigation? So, a lot of people, I think, they follow immigration practitioners on social media and similar platforms. And like Mr. Murin said, even this podcast will have some viewers and they will also understand some aspects of incompetent counsel. Uh, People have to understand that social media is not a platform where legal advice can be followed, obeyed, or tracked from the practitioner's point of view. I see many practitioners posting serious legal issues and not even telling the general public, basically not alarming the public that this is not a legal advice. A lot of them go online, and even when they're announcing the policies or something, it's not limited to just an announcement. It's limited to, they go beyond that. They even tend to advise people on the
Yeah,
eligibilities and those kind of things. So that is the starting point of this whole issue.
for
And
sure.
I think Mr. Murin's given his experience, and you, given your experience, can um, tell people what to be caution of right in the beginning when they're choosing legal counsels or other
For sure.
immigration practitioners. Yes.
Oh, yeah.
I think that's a great starting point. I mean, I think that, I have come to embrace Copilot, I will say, but at the same time, I think that I too have found myself tempted to be like asking Copilot legal questions. And I think that one of the challenges of there being so much information available at people's fingertips is that the value of legal advice has become reduced. Like, I think that we do need to recognize that I've always been sort of like opposed to this idea that the legal profession is under threat, because I don't like that kind of alarmist approach at all. But I do at this point feel like there is a competition between publicly available information and actually seasoned, sophisticated advice. And I think that it is and also because of the way that policy and practice has proliferated, where it's almost impossible for even a very vigilant, diligent lawyer to keep up with all of the new things, changes, fixes, like they're not even available sometimes. Like I was trying to look at what the policy guidelines were for something. What do they want? What is the test right now for assessing a temporary residence permit? What are the factors that officers consider? They're no longer available online, and they're doing that to deter people being able to pull forward the program manuals, but this hiding of the actual criteria with the putting forward of more like just AI tools and stuff, it's made it very, very difficult. And so unless you're going to actually go and read the jurisprudence and pull out these principles from the cases, there's a real competition between what's gumming up the front end, the user experience with all this data, and what is actually substantively going into decision making.
So let's get into what the test is for incompetence of counsel. It's a 3-part test. I'm going to list all 3 parts, and then we can get into each one individually. First, the previous counsel, because I think it's obvious that you wouldn't go to federal court and argue that you were the incompetent one. Previous counsel's act or omissions must have constituted incompetence or negligence. Number 2, a miscarriage of justice occurred, which means that but for the alleged conduct of the previous counsel, there's a reasonable probability that there would have been a different result. And number 3, the previous consultant or lawyer had a reasonable opportunity to respond to the allegation of incompetence against them. Let's start with the first one and just get into this distinction that I think Deanna has started to hint at of between incompetence or negligence and something like, say, a mistake or something like that. I don't know if you want to elaborate. I can give an example of both. Well, why don't I say a little bit more about kind of what the law is, and then I can give an example of an incompetence of counsel argument that I made where we succeeded on the first point, didn't succeed on the second point. And then the third, this was before the requirement for notice even existed. So in terms of what does constitute incompetence or negligence, there's a range of conduct that a lawyer or a consultant can have that the courts will find reasonable, right? Like not every mistake or strategy is going to be found to be incompetent. And one example that we can give is in kind of an example of sharp practice, in my opinion. There was a lawyer, it's about a decade ago. There was a lawyer at another firm in town who called one of the lawyers at our firm asking for their opinion on how they might have handled a certain case. There was no client name given or anything like that. And the lawyer at our firm said, okay, well, based on that, I probably would have recommended this approach for this complex appeal. And the lawyer at the other end was recording it and then used it in an incompetence of counsel argument that was ultimately dismissed, saying they said they would do this, but in the actual case, they did this. And it didn't really go anywhere because there's different strategies that can be taken. Also an example of sharp practice.
Wow.
The one that I argued in federal court, where it was at the Immigration Appeal Division before Kashimatu, and the person was represented by someone who wasn't a lawyer or a consultant. They had put that they were just a benevolent helper in the form. The case name, for those who want to read it, is BV Canada, Citizenship and Immigration 2022 FC 293, the proceedings were a disaster. Like a few minutes in, Member Matu basically told the representatives to sit down, that they weren't going to participate any further. She took over the proceedings and she concluded the hearing, by saying, quote, "I'm going to reserve my decision, so the decision will be provided to the parties in a few weeks. I'll just make one comment. In future, if either of you intend to assist people, either at the Immigration Appeal Division or somewhere else, you ask that organization what the rules are and follow those rules well before a hearing date, and in fact, observe a hearing because they're usually public. So you're aware of what to do or what you can do or not do to order to better assist whoever you're attempting to assist, because you might not get as much leeway as you would in these types of circumstances. It's generally not helpful to anybody to offer assistance when you're not sure what you're doing." End quote. And that's how the hearing ended. I used to play the audio of that to new lawyers that we hired, being like, "This is what you never want to happen at any of your appeals." So we were successful, obviously. Like, if there was ever an incompetence of counsel at the first part of the test, it was obvious that the people who were helping this person were incompetent here.
Right.
What about some of those more borderline situations, though, that like you could conceivably think of? So I'll give an example of one that the Lawyers Insurance Foundation in British Columbia sometimes asks me for my thoughts on whether something was competent or not. And the example that they were grappling with was doing an express entry profile where you just enter a knock code based on a job title without going through in detail the list of duties. Obviously not best practice. Do you think it rises to incompetence? This isn't an active case court or anything.
I think the situation where immigration now is every practitioner is supposed to be super diligent because they're changing policies on day-to-day basis. Um, uh, there were days, even in, I'm not sure because I'm fairly new to Canadian legal system, but uh, in every common law country, procedural laws and guidelines, they used to be lubricants in the aid of justice. They used to act as lubricants. Now, if we look at immigration law in 2024, 2025, uh, procedural policies and procedural laws, they have become barriers. If you have not included something, okay, substantive law says this is being returned. So a lot of guidelines and procedures, they're super heavy on substantive provisions. So we are in a different, even in immigration law, and I think this is the situation in almost every other area of law. And this is most of the common law jurisdictions, they're facing these things these days. And I think in express entry process, given the volume of refusals, given the nature of refusals these days, um, I'm not sure, but competence requires to do a proper detailed assessment of the
Yeah.
duties and NOC, and then that is the preliminary step. Even before creating the express entry, one should be conscious enough to identify the proper NOC, given that we know that there is jurisprudence like Gopalakrishnan versus Canada, in which the court said Section 16 plus 11, Section 11 of the immigration law expects people to submit true, correct, and complete application. So they're very firm on this, and even the jurisprudence favors those kind of situations.
Yeah. Yeah, I would say that in this situation, these circumstances, I would be arguing both that it was unreasonable for them to refuse on the basis of the wrong knock being chosen. Because it's one thing if the knock was at a different tier level, and that there's another, like you're saying, architect, when they think it's an architectural technician and there's some substantive difference between one, it's not the case in fact, but like one classification would be different points assessment than the one that they think is the more appropriate knock assessment and doesn't qualify them for the program. If it's that kind of a thing, then to me it's a clear case of negligence. But if not clear, it's a much more persuasive case for negligence that I think goes right to the heart of the advice as to whether or not the person qualifies for the category. But I think where it's something that is more like, I think that knock assessments are among the most complicated things that solicitors are required to do. And I think for the court to say, well, you just picked this knock and it should have been that for the immigration department, you picked this and not that. Like knocks are kind of an artificial construct in the first place, but that really the fact that they have been so artificially tied to doing those assessments of eligibility, that I think that that's a misreading of how the legislation was intended to function. But I think that this just invites me to argue to say one further thing, which is that we're not talking about incompetence, negligence in the same way that you would if we were talking to Owen Logan about, like, have you been negligent in a sense that you require discipline. It's just whether or not your conduct, like I just don't know if the case law on incompetence goes to this degree of nuance. Is it whether or not the conduct substantively led to the negative outcome faced by the client? Because I think every immigration lawyer would and should clearly know that a CEC assessment, Canadian Experience Class, entirely turns upon whether or not they're going to accept that job description is a match for the lead statement of that occupation. And so it goes very much to the core of it. But I think we have to deal with a different definition of negligence in the context of incompetence of counsel pleadings than we would in a disciplinary proceeding. And I just don't know, Arshdeep, what do you think about whether or not that degree of distinction is actually available, or Steve, either, in the case law? It's because they're totally different objectives. It's not about penalizing counsel. It's about making sure that the client's rights aren't prejudiced.
Yes, Mr. Murins I think he can answer it in a better way.
I think that it's one of the more tricky, trying to determine what will actually meet the threshold of incompetence versus an approach on a file is really difficult, as with many areas of immigration law. Like, there will be arguments made. I'll start reading a court decision, and unless they say at the outset, this judicial review is granted or this judicial review is dismissed, as I'm reading the facts of what happened, I'll start to form an opinion one way or the other. Like, okay, I think this will meet the test of negligence, or I think it won't meet the test of negligence or incompetence.
Yeah.
And sometimes I'll be right, sometimes I'll be wrong. So I can give an example of the one that I shared around the firm when it came out, of what I thought was something that I knew the mistake that the lawyer made, but I'm not sure it rises to the level of incompetence. And so that is, the citation for this case is Brown v. Canada, Citizenship and Immigration, 2024, FC 105. A Canadian immigration lawyer is reading a UK police certificate that says no live trace.
Oh my goodness, this is such a trap.
Okay, do you want to explain? You obviously know the issue, yeah.
I mean, I know the issue, but again, like,
well,
it's not just
explain what it is. What is it? What it
Okay,
means.
so when you get a police clearance from the United Kingdom, it's supposed to say no trace. No trace means no criminal record, means your police clearance is clear. But if it says no live trace, there's more to the story. It means that they might have a caution, they might have some other kind of a record that maybe doesn't rise to the level of a prosecution. So that is a clear meaning within the UK context, but it doesn't have a clear meaning to Canadian immigration lawyers. So I know this one for the UK because we see UK clearances regularly, but what happens when it's South Korea? What happens when it's the Philippines? What happens when it's a country that you've never encountered before? How are we as Canadian immigration lawyers supposed to understand the nuances of police clearances from every country around the world? I was stymied once with a South Korean police clearance, where again, there's one line that's supposed to appear that says that it has searched not just the I don't know. There's just one line that either it's there and then it's considered to be a valid police clearance for immigration purposes, or it's not there, meaning that it hasn't checked one further database, and then they will reject the entire application as incomplete. There are these very small nuances with each one, and so no live trace means you still need to continue digging, figure out why it's no live trace rather than no trace, and then speak to potential admissibility concerns to establish that the person's not criminally inadmissible.
The other confusing part with South Korean police certificates, there was a live issue a few years ago where they started to say that if it was disclosed, the full record, then that in itself constituted a crime. And I remember all these lawyers going, well, okay, Canada's immigration department, you're demanding that they disclose this document. You're not going to turn around if they do and then say, now you're inadmissible for having committed a crime.
And by the way, there's the same issue with Philippines police clearances. No derogatory record, no something record, or no criminal record. No criminal record being the one. Anyways.
Justice Norris found that it was incompetent to not know that as the Canadian immigration lawyer. I was surprised that rise to the level.
So one of my friends, she practices immigration. So she had the exact same issue related to the UK police clearance certificate. And I think the counsel who was doing judicial review, he was trying to follow the court guidelines on this process. And that was the point where the counsel on the other side, he had good experience in immigration law, some with a big name. He sent a letter stating that why you failed to interpret this uh, police clearance properly and in a accurate manner. So she explained her side, and also she included her questionnaire that she sent to the client, stating a simple question that were you ever found guilty of any offense in Canada, in the United Kingdom, or anywhere else in the world? So the client had answered in vetting that there was nothing like that, and she sent that questionnaire as well. And the lawyer on the other side, I think, dropped the idea of pleading incompetent counsel ground further because uh, he understood the issue that it was client who was trying to even hide this thing from the lawyer. So sometimes these kind of situations also prevent us. Let's say if we get police clearance from Nigeria and it says it something that does not lead to a situation beyond reasonable doubt that this person has clear criminal record. That is the second way of identifying things, and obviously clients, they're expected to be truthful to the lawyers, and the lawyer on the other side, he emailed that he has decided not to proceed in this matter further given that this was the issue. So
yeah, I mean, that brings us to the third point, and we can collapse. So the second part of the test was that there has to have actually been a miscarriage of justice. So in the case that I mentioned earlier that I lost, we were unsuccessful in showing that the fact that the IAD member made the representative sit down and ran the hearing on her own. The federal court found that while that wasn't ideal, she did a good enough job and that there wasn't a miscarriage of justice. In the case, and then the third part of the test is there has to be this notice to the prior representative. And so it sounds like in the case that you're describing, the client initially alleged incompetence. You went to or your colleague went to the prior lawyer, and it turned out that it wasn't quite what the client had said.
So the client basically retained a law firm, senior counsel, somebody who has been practicing immigration law since last 20-30 years. And the client wanted to proceed with this ground, I guess. But the whole issue ended when the lawyer, the previous counsel, got an email from the current lawyer of the client who was representing the client in the federal court. And the issue was resolved basically based on the checklist and the questionnaire that the previous counsel sent to the client, where client had indicated that there was nothing outstanding ever against the client in the United Kingdom or anywhere else in the world. So maybe it is difficult to, obviously it is difficult to plead incompetent counsel ground. So maybe the facts were such that the council decided to withdraw the case and not to proceed further in a matter. So sometimes the situation is difficult, that if somebody is banned for 5 years for misrepresentation, they don't have choice. They continue with the litigation. They try their luck on that side, but a lot of people who are not banned for misrepresenting, who are simply refused or denied, if they have an option to reapply, they choose not even to proceed with incompetent counsel ground, because it's really difficult to practically meet the test to allege this in the court, in the litigation. Even if we look at the matters on appeal side or in judicial review side, um, it's really difficult to plead.
I think that, I mean, the third component of the test is where I think the majority of the cases, I'm not sure, I haven't done like a comprehensive review, but a lot of them are failing in that they're not following the very strict protocol set out by the court as to how you need to make the allegation, which includes providing notice to the counsel who the allegation is made against, and they have to be provided an opportunity to respond. Even if they don't respond, you need to show that those efforts were made. And so, we can link to the details of how the protocol works. But I think in terms of the difficulty of making out the claim, it does go to this question. Like, I think that the test that is being imposed is whether or not, or the test that is being used is whether or not there's a reasonable probability that the result would have been different, but for the conduct that was undertaken by counsel. So I think,
keeping in mind that applicants are responsible for who they hire, which
yes,
is another
exactly,
principle in Canadian immigration law.
Well, I think that that's exactly right. And maybe that's where we should sort of veer in the second part of the conversation, that I think, first of all, demonstrating a reasonable case that the result would have been different but for, I think that is the first challenge, the real challenge, assuming that you've abided the constraints of the protocol itself, that the outcome would have been different. In a situation like the one that you gave the example of, Steve, that the result would have been different but for, I think would be a fairly straightforward thing to establish, that were it not just the wrong knock code, if all of the other requirements of the program were met and that was done, then yes, if that was the basis for the decision, that should be fairly straightforward to be able to establish. Because I think that they're just using a reasonable, fairly arguable case. I think that that's a pretty low standard, actually. But again, I think that it's this second part of it, which is whether or not whether or not they're going to then impose upon the applicant some, like, if it was a misrepresentation that was made by the counsel and that was the incompetence alleged, wasn't the duty on the applicant to have actually reviewed the forms before they were submitted. You can't just say, well, no, that was my counsel did that. That's definitely not going to work, because if you have given somebody authorization to act on your behalf, then you're responsible for the representations that they made in your name. And so I think that then they get into this more complicated discussion about choosing counsel and not delegating and abdicating responsibility when you make that delegation.
Yeah, not just the jurisprudence tells that, like Mr. Miran said, you are responsible for choosing the kind of practitioner you're choosing for yourself, because there is a rule that buyer be aware. If you're buying something or if you're obtaining a service from someone on professional side, you have to be conscious enough and diligent enough before choosing a product or a service. Similarly, if you're choosing an immigration counsel, you have to be people are required to be more diligent while
For
choosing it.
sure.
And not just the jurisprudence supports this thing. Even if we look at Section 40 misrepresentation provision, a lot of people try to plead that their practitioner did something wrong while misrepresenting, or even if there is a mistake related to Section 40 overall, they try to plead that it was not them, it is their counsel who did this thing. So Section 40 is very strict provision, I would say
Mhm.
one of the strictest provisions in the immigration law. It holds people accountable
For sure.
because indirect misrepresentation, as per the provision, is also a misrepresentation. And on top of that, court has decided in multiple cases that even innocent misrepresentation is still a misrepresentation, even if it was indirect misrepresentation done by a family member, done by a son, child, parents,
100%.
or um, an immigration counsel. So,
Yeah.
yeah.
I think with misrepresentation, there have been cases where incompetence of counsel was successfully pled, where it could be shown that the representative was aware that someone had a previous refusal, but didn't disclose it in the application or even changed a form before it was submitted.
Or forged
Uh,
a signature or
or
created a dummy account, all these sorts of things. I've
Well,
experienced
even
those.
not to that level, like until recently, and still with the authorized rep form for express entry and things like that. One of the weird things was that the applicant couldn't see
I
their
know.
profile and what was actually being submitted, and you really just had to trust the person,
Totally.
the lawyer or the consultant. Now with the newer portals, it's different because both parties, both client and representative, have access to the portal. The application can't be submitted until both sides have signed off that everything's
Yeah.
accurate. But before this, there were these issues of that was sort
Scandalous.
of weird, where like the client wouldn't actually have access to their application or see for sure what was submitted.
Yeah. Yeah, it was actually quite scandalous in my view that like those you're considered to be responsible for the submissions made, but you cannot actually see them.
And it is really important for new practitioners to even understand this part, that sometimes they'll have because the test requires that all the reasonable foundations that they are alleging that there was a incompetence of a counsel, sometimes they'll have visible evidence to support that. Evidence is needed to support that there was a actual incompetence in existence. So sometimes there is a visible evidence, and uh, new practitioners, they are overwhelmed. They come to a conclusion that there is a cogent evidence against this situation, now they can use this in the court.
Yeah.
But it is important to understand that the court is not flexible on the requirements, on the guidelines. For example, if somebody is trying to plead this thing before the appeal division, or in the judicial review side, in the federal court, I mean, uh, there is a strict procedure to follow. And if there is, even if there is a minor lapse in the procedure, courts, they discourage this as a ground. And even in 2025, federal court has affirmed in some cases that the procedure is really important. So uh, if someone has evidence, someone has even after correspondence with the counsel, previous counsel, they have strong evidence to establish incompetence, the procedure part is really important. If that is ignored, the whole case fails.
Well, I think that you're touching on another very important point, which is as a new practitioner, I think it's very important to understand that your clients, if things go south, may rightly or wrongly, knowingly or unknowingly blame you in the future
Mm.
for anything that goes wrong. And that kind of goes back to some of the key principles that you learn about being an effective lawyer in law school and when practicing for the bar, like taking notes,
Yeah.
trying to correspond in writing. Because sometimes when you'll see someone coming and saying, my previous lawyer said this, my previous lawyer said this, when you get all the documents, you'll realize sometimes it's the complete opposite.
Yeah.
And to rush into incompetence of counsel claims, now there's the notice requirement, part of which is that the consultant must waive, or not the consultant, the client must waive solicitor-client privilege. We had one case where someone was wanting me to make in a consultation, an argument of incompetence of counsel. And I said, okay, well, I need you to waive so that I can get the document. No, I really don't want you to see the emails between me and the previous lawyer. And I went, that's going to be a problem.
Yeah, for
So
sure.
it's just something to watch as you're definitely as a new lawyer or consultant is A, try to get things in writing. B,
Yeah.
assume that anything you put in writing will be shared.
Yeah, 100%. I also think that we need to be very aware of the standard of care, not just to cover our own behinds, but because the consequences are so great. We need our clients to be engaged in their own immigration process. This is not something where they can take a backseat role. When you've prepared a submission, they need to go over it, not just signing on the bottom line. This is not the way that many of us sign our tax return documents. You need to go through it. They need to understand it. They need to engage with that material. And so I like, whenever possible, to go through the submission, not just send it off. Please send it back to me with an approval. I want to, wherever possible, I go through the application with them in real time. Okay, we've said this, no problems, everything's good, and then it's then really I have, not just because I'm covering my butt, I'm also I have a sense of satisfaction that they have actually consented to the information that I'm inputting for them. You think it's going to be a big time waster, but in fact, sometimes it's easier when you just are sitting there on Zoom with them and you're like, okay, you're good, now push this thing, rather than 16 emails back and forth about, no, you didn't, right. So and then you've really actually accomplished that service in a way that satisfies both sides of it, and you can document it. It's sadly, there's still a lot of types of applications that you cannot share in the same way, like PRA applications, refugee claims, that still they cannot in real time see what you're submitting to the immigration department. So it's funny that the most vulnerable people still don't have firsthand access to the claims being submitted, where that should be the most important. But there it's even more important to be absolutely vigilant and make sure you've gone through things with an interpreter if necessary, to make sure that content is fully approved and that your client is signing off.
So usually incompetence of counsel situations, they can lead to mainly two different situations. One is where things are still fixable. There, for example, incompetence of counsel led to a situation of incomplete application and the application is returned. That part can be more related to human error, negligence, and those kind of issues like we were discussing earlier, negligence and incompetence. And still, the applicants, clients, they have chances to fix their situations, reboot their immigration matter again. But on the other side, in case there are serious consequences, the second situation that leads to, incompetence can lead to is a serious situation where somebody is banned for misrepresentation. And I think what Diana is saying is that uh, incompetence is one issue, but clients are also expected to review things properly, nicely, because federal court doesn't support this fact that okay, my representative did everything and I wasn't participating in the process. If somebody is not active, diligent, and a- active participant in the process, and that person cannot be given relief by the courts as well. And people who practice immigration law, practitioners, uh, they have to be very careful in the entire application while they're doing the final review process with their clients. Uh, Particularly admissibility section of each application. What I try to do practically is I try to follow all the protocols and that are going to protect my license in case of any issue in future. But at the same time, because I come across people who do not speak English language, people who do not have good skills to even read English language. So I try to explain things verbally as well, and particularly admissibility section, because if something goes wrong, that may be irreversible. So
For
yeah,
sure.
that is really important. Yeah.
I think it really is, and this is going back to the big rant at the beginning, is that I think that this is a transformational time, because I think that we're all having to practice in quite a different way. It's not like in the old days, and I don't mean to sound like an old fogey, where you can just create an application, send it, and be like, yeah, can you just review this? Where it's like now, just a minor issue, such as like a no trace versus no live trace, even if you're dealing with a country that you've never dealt with before, that not knowing that that one word live is the difference between getting landed and being able to remain with your family in Canada and being rejected and never having another opportunity to apply for permanent residence. Everything turns on that. And while there's no consequence to you as a lawyer, for being found incompetent by the federal court, it does have a reputational kind of connotation to it. People are upset, the stress, the mental health impact of having somebody make an incompetence allegation, but also just the fact that, like, now, how much time are we spending reviewing every kind of thing? How has it changed the way that we practice law? What does it mean to our fees? Like if we are having, or like even just some of the issues we're having with federal court, like if you're trying to file something with federal court and it doesn't just get uploaded when you're ready to submit your record, but now you need to spend 2 hours on the phone with the registry office, no fault of their own, but because of their volumes, so we're having to pivot around all of these things, trying to bridge the obligation to meet our ethical and professional obligations, trying to serve our clients' best interests, and trying to meet these ever-changing, ever more complicated, ever more, I don't know what the word is, baffling processes and procedures that it's almost impossible for a human being to keep up with. And that doesn't mean that it would be better done by a robot, because the robot machines are not working either. That's part of where the problem came from in the first place.
I would like to add third part as well. First part is protecting your license, sending something through emails or getting in writing confirmation that everything is correct and we are good to proceed. Second part, like you mentioned, is repetition is something that how we practice things, and also in terms of revenue and business for future clients too. You have to be careful. But third part is even if we go beyond that, life and file, these are two words composed of same alphabets. It might be a file on the table, but it's someone's life. So active participation during the review process with someone can avoid so many problems for us as practitioners. Second thing, repetition. It will protect our reputation throughout. And third part is the life plans of someone will not get impacted just by engaging the client actively in the review process. So this is really important.
For
As you
sure.
say, it's someone's life. Like it's hard when someone also comes to you wanting to make a claim of incompetence of counsel. Like I almost feel dirty doing
I
it.
know, honestly, I feel the same way.
When the
And it's
notice first
stupid because I
came out,
shouldn't. I want to advocate for the client. I want to get
uh,
the outcome. I would have no, if you got one from me, Steve, I would be like, knock it out, like go for it, because I want the client's interest. That's my ultimate goal, is to make sure that the client's interests are achieved. I would admit to a mistake that I had made, because it's not the way that I see it. Some of these are, yes, that is a mistake that I made. It wasn't because I'm not a good lawyer. It's because it's impossible to be a good lawyer
yeah.
right now. Yeah.
One of the things
Sorry.
that they did with the notice, and I pulled open because I wanted to make sure I remembered this, was when the requirement to provide notice to counsel first came out. It had this sentence saying, any relevant evidence shall be included in the motion record and filed by way of affidavit, including any response from the former counsel or authorized representative and documentation of a complaint made to the appropriate provincial or federal governing body.
That's
was how the
brutal.
notice first read. And it created this like,
Oh my
maybe
God.
something could be considered incompetent in the immigration context because the standard is lower than what counts as negligence. But filing a complaint with the regulatory body felt especially like,
Oh,
ugh.
that's awful.
Now it's changed to say if a complaint has been made to the appropriate provincial or federal governing body, evidence of this must be included. And don't get
That's
me wrong, where the situation is warranted, like I've helped people file complaints against both lawyers and consultants, typically where there's blatant fraud that's been
yeah, for
documented
sure.
in writing. But like the live trace, I wouldn't want to report someone to the Law Society because they
Oh
didn't
my
know what
gosh.
live trace was. I would
Yeah.
still make, I don't know, until the decision had come out, I actually wouldn't have thought that that met the threshold of incompetence. That decision actually made me realize how broad the argument could be and what scenarios could be encompassed.
Well, we're trying to be supportive. I mean, this is a really hard time to practice immigration law, and I won't um, hide the fact that like there have been numerous times over the course of the last year that I've debated whether I want to even continue practicing immigration law in the last year because of how grueling it has been, because of how demoralizing this practice has become. And so when other colleagues, brilliant lawyers, like the top practitioners in the country, are like, should I have done this? Was this a mistake? Not because of negligence, by no means negligence in the big picture sense, in a way that could have attracted some kind of disciplinary action, but because the system is so hard to understand and because the tests have become so convoluted, that's the kind of support we provide one another as colleagues. Yeah, I wouldn't have done it like that, but here's why. Here's an alternative. We're trying to support one another collegially. But at the same time, the remedy we want to be able to offer to our clients is to be able to pursue an allegation against another lawyer who may very well be absolutely doing things to the best of their knowledge and ability. But so again, it kind of pits us against one another. I think that there are clear cases. I don't know. I just wish that I mean, I'm glad that they took out that component of the protocol, but there is a tension here in terms of the idea that it's counsel's fault and not the fact that it's not tied back to the that there's no qualitative assessment of eligibility, and that it really does rest so much on counsel's shoulder to know everything, that even given the complexity.
Yeah, I think many of the issues can be avoided. A lot of, I think, people who are going to watch this podcast, they're going to think, so what is the solution to this? I think a lot of situations, just to take one example again of this UK police clearance certificate, um, I think it is really simple to avoid these kind of mistakes. If we are not sure on anything, it's easy to raise that kind of question on platforms like CILA listserv, CBA listserv. The beauty of immigration bar is that you raise a query, you ask something, so many people pitch in to responding to that question or concern of their colleagues. So it's easy to avoid many things, just like basic things from UK. Even if we have police clearance certificate from South Korea, like we were discussing, uh, if somebody is not having good handle on those things, somebody's seeing foreign documents which are absolutely foreign to them, it's a good idea to raise those kind of basic concerns in the listservs. And for example, if I am getting some client from Nigeria, and in case I have issues understanding and reading certain documents related to a particular jurisdiction, I would post on listserv, and someone I know will respond to that thing, and somebody who has actually experience of dealing with that particular situation.
For
We have so
sure.
many foreign trained lawyers in the bar who come from different jurisdictions. They bring different charm to the bar.
Yeah, yeah.
A lot of times, many times, I get emails related to Indian legal matters related to family law or criminal matters. So it's so easy and simple to use resources like this just to avoid minor issues.
Yeah. I mean, I don't agree with you that it's easy, but I do think that it's critical. I don't think it's easy to stay abreast of all this stuff, but I think that really, I think that's what Steve and I have been trying to accomplish with this podcast is to keep putting these types of issues in front of people, to be like, here's something to watch out for, to make this type of information as easily accessible as possible, to draw out the nuance, to create a more collaborative environment where people are like, here's something to look out for, here's something to watch, and to I think we all need to be incredibly vigilant, but also incredibly supportive of one another. And also supportive, not just in terms of like, I'm going to give you a hand, I'm going to tell you everything that I know about this to kind of help you advocate for your client in the best possible way. We have to stop that law school thing of like, sharing our materials and ripping pages out of books. I think people really need to share in order to help us all help our clients in the best manner possible. And I think also ultimately, to just manage the mental health component of it, that like if somebody brings an incompetence of counsel claim against you, that doesn't necessarily mean you are a bad lawyer. You might be the absolute top of your practice, but you just happen to face a situation that, in all of your years of practice, we are all humans, that like you've seen a Nigerian police clearance for the first time and didn't understand that this specific notation meant something different than that specific notation. And really, we can't know everything. But for clients, that's what I think my 2 points are for how this should impact on how practitioners act. From clients' perspective, clients should be absolutely vigilant also when they're dealing with counsel. If they feel like they're not getting the whole story, if they're getting promises that sound too good to be true, they are. If they're not, if in any way, at any point along the way, they lose their trust for their representative, they need to move. They need to either confront, they need to move, they need to be proactive. They cannot just be like, well, this is my representative. It will be too complicated, because the consequences of remaining with somebody who is not acting in your best interests can be fatal. They will follow you, especially if you've had red flags and you continue to work with a person that has shown red flags. That will 100% be impugned. That will impugn your continued reliance on their services.
Yeah, so if Mr. Mirans can share this with the audience, that what are those red flags people should be careful of? If you can share some 5, 6 red flags.
Yes, Mr. Mirans, tell us.
Steve, what would be my number one red flag that I see? The big one for me is not sharing the application with the client.
That's it.
I'm always surprised at how often that is, where you're like, oh, can you show me the application? Oh, my consultant or lawyer never gave it to me. That's probably my biggest red flag.
And not explaining things, not like, if you don't understand what process you're going through. And again, sometimes you can explain and they still don't understand, but that's because it's just so convoluted. But like, there should be sometimes just, and I know that the biggest red flag that the Law Society and that, all sorts of other organizations always talk about is lack of responsiveness. And I know that is often the key red flag for clients, but sometimes that to me is a bit of a red herring, so to speak, because if your client is following up every week to find out what's the update and they're not getting a response, it might just be because, if you've told a client that it's going to be a year and then they follow up every week, they will stop getting responses at some point, because that doesn't mean that you should not respond. Of course, you should keep responding. But if every update request comes with 36 questions, that level of service might start to fall off, because it's very hard to keep giving that kind of detailed responses. You end up basically working not just for free, you end up paying to continue working on that file because of how much time you're spending and how much time it's taking away from urgent priorities and deadlines and all of that sort of thing. So I just caution about that one.
Counseling misrep, obviously.
Oh my gosh, yeah. Yeah.
I don't know if I have it beyond that. Do you have any Arshdeep that you've seen where you
So
think, whoa, this person should have spotted something?
I live in a city where we have a lot of young international students in the city in Brampton. So almost on day-to-day basis, I keep coming across people who participate in these kind of things, who are properly coached by immigration practitioners to make those kind of mistakes. So it's
When you say
not as,
practically coached to make mistakes, do you mean to
yes,
lie or
to
to like,
lie, to forge documents, to
Yeah.
run fake payrolls. They wouldn't advise them of the consequences. They would encourage. I recently came across a client who had a genuine job at a particular place, but the client was never aware of this fact that the employer was running fake payrolls of 35 other individuals from that same company. So one of them might have been caught, and this genuine actual client, I mean employee of the company, he also got PFL. So he had extensive evidence to establish this thing, but they debarred the OINP, they debarred the employer from supporting PNP clients. So he
Yeah.
suffered as well. So these
I've
kind
heard
of
Brampton
issues,
is particularly, I don't know, like obviously you practice there, but I've heard it's tough for ethical practitioners because there's a
Yeah.
lot of unethical stuff going on. I don't know to what extent that's true. It's just something I've heard from a few
Yeah.
people.
I've heard some people saying the same about Surrey, that it's like people are avoiding, and I think it's an overbroad characterization that like an ethical practitioner in Surrey is now being taken down by by others, and so but I think that I think that really the message you're saying here, Arshdeep, is about like you have to use your sort of your nose, your spidey sense, whatever you want to call it, but that like really immigration operates almost like a
law
priest,
enforcement.
rabbi, imam. Like you have to be like, imagine this like very strict ethical moral judge, and that if
Oh, that's where you're
anything
going.
is
Okay.
being recommended to you that would not be I'm going to say kosher, with that imam, rabbi.
Well, unlike, would you ever go to immigration and confess your sins?
Yeah.
Yeah,
So
like if you think, just go like look to your gut. Now I'm doing the yogi version of it. Think to your gut. If you would feel like an immigration officer is not going to like hearing what the representative has just suggested to you, then it's probably wrong. And so don't ignore those warning signs. Listen and be like, that sounds creepy. Let me ask somebody that sounds like, I'm going to ask 6 different people if you have to pay 6 other consultation fees to be like, this sounds highly unethical. Can you tell me? Or even ask the person, doesn't this sound like a misrepresentation? This sounds fraudulent. Explain to me legally why this would not be, and unless you like, don't just, oh, this is out of my hands, I'm going to give you the reins.
Yeah. Well,
like he
you,
mentioned about
oh, go
Brampton,
ahead.
this is a very common client consultation. The purpose of consultation with the lawyer here sometimes is I often do those kind of consultations. Somebody is advising me to run my payroll in skilled trades or in healthcare, or do XYZ thing. Should I proceed with it or not? And then I always print section 40 and explain. My whole focus in the consultation is to advise them on this word indirectly in section 40. And obviously the fraud and this unethical guidance, coaching for misrepresentation is common. That is why we see people doing consultations from a law firm on
Sure.
this thing, whether they should be
Right.
doing it or not.
Yeah. Well, similarly, like, should I get married? Like, who am I to tell you whether or not you should get married or not get married? Like, I'm an immigration lawyer. I'm not a marriage advisor, like, do you want to get married? If so, I will advise you about what your immigration options are. If you don't, then I won't go down that pathway, And
Yes.
so if somebody's telling you, maybe you should get married, maybe you should think about getting other legal advice, like
Yes, in
just
certain
saying.
situation, yeah, in certain situations
Or
when
the
you
other
tell,
opposite, should I get divorced because my spouse is inadmissible is another one that we
Exactly.
had asked.
yes, many times clients would want us to answer things like that, this, that, um, related to marriage. Sometimes they, uh, as practitioners, when we tend to tell them that, okay, you are inadmissible, you're facing removal and all those things, you can try your luck finding someone who's a Canadian PR or citizen, and this might help you save your stay based on humanitarian and compassionate grounds, but things are difficult. So a lot of people, they tend to even tell me that, can you find me a match from some from your pool of clients? They try to do those kind of things too. So yeah.
Yeah. Anyway, we got to wrap up. A
Yeah.
consultant recently told me, it was funny because Deanna was saying one of our goals in the podcast is to alert people to all these things. A consultant recently told me that they listen to our podcast every week, and at the end of every episode are a stressed out wreck of all the things where they're going, oh, this is a thing, this is a thing, this is a thing. And I am sure that this episode on incompetence of counsel will be no different with all the different issues that we've raised. But yeah, I hope everyone listening has taken away both kind of some issues that arise with this ground of challenging a refusal and both that it exists. Arshdeep, thanks for coming on.
Thank you so much. And my team and I extend heartfelt thanks to you both, because you both are guiding light for so many practitioners, not just young lawyers, but for so many of us. And the topics that you do, they're really interesting. People are getting educated on this subject. And I think we are trying to use this newer technology and everything in a very good way. And thanks to you both for your efforts, time.
Awesome.
Yes. Yeah.
Thanks, Arshdeep.